All right, we will go on the record in the matter 24 CF 247, 24 TR 118, 25 CM 201, 25 FO 248. State of Wisconsin versus Josie Taylor. The state appears through District Attorney Kevin Schmidt in person. We have Zachary Fisher, Defense Counsel in person, as is Ms. Taylor. We're set today in this matter for plea and sentencing. I've been sent a note from our clerk indicating that Ms. Taylor has prepaid $2,500 in restitution and perhaps other things. I'm not quite certain. All right, are we ready to proceed?
Yes, Your Honor.
Do we have any, are we in victims' rights compliance?
Yes, Your Honor.
Victim making a statement?
Yes, Your Honor.
All right, please have, how many victims? One victim can come up here, state your name for the record or your initials, whatever you feel comfortable with. And you can be seated. And please speak into the microphone so that the court reporter can make sure she's able to get everything down. And if you are going to read something, please read it slowly and just take your time.
Okay. My name is Edward Kinsner Jr.
Could you spell the last name, please?
Kinstner.
Thank you. All right, you may begin.
Hi, Josie. My name is Ed. I am the one that you hit on the morning of November 16th, 2024, and then walked away from the scene without seeing if I was still alive. First off, I hope you realize how lucky you are that you didn't kill me, you, or both of us. Hopefully you learned a valuable lesson from this, and it will help you make better decisions in your future life. You took away a lot of personal, financial, and physical things from me that day that I will never be able to get back. I was forced to retire early from my United States Postal Service job because of the injury that I sustained. I will no longer be able to perform my job. So I had to retire early, which cost me hundreds of thousands of dollars. I'm not the one to determine the punishment you should receive, but I do hope that it is enough for you to look in the mirror and realize what you have done to me and my family. And I hope that you learn a valuable lesson and make better decisions when it comes to your future.
Thank you. All right. Mr. Fisher, what is the agreement that's been reached?
Your Honor, the agreement calls for Ms. Taylor to plead to an amended count 1 in 24 CF 247, amended to operating while intoxicated second offense without the causing injury enhancer, as well as pleading to count 1 in 25 FO 248, underage drinking first offense. Remaining counts and traffics and the 25 CM matter would be dismissed and read in. There is a joint recommendation for a little bit of a different version of the IDIP guidelines for a second offense, given the large amount of restitution at issue, to provide for an avenue for Ms. Taylor to be required to make those payments with the court and have methods to ensure that she is making those payments while also providing an avenue for the court to punish her if she fails to do so in the future. It would call for 1 year of probation with these OWI second IDIP guidelines, where the 5 days of jail will be conditional jail that she would have to serve either in custody or on electronic monitoring. We are requesting the court grant her 15 days to get set up with that electronic monitoring, as she was not able to pay the $150 fee upfront, given that she paid most of that money that she was able to save up over the past year towards that restitution that she's paid. The joint recommendation would call for a $976 fine, as well as stipulation to $22,602 in restitution, with the $2,500 upfront payment. There would be 12 months of IID installation and revocation, 25 hours of community service, and the mandatory fine in the 25 FO matter.
All right. And I know you don't generally represent with the FOs, in particular with the underage drinking. So I'm not quite sure if you were aware of the parameters, but this is a first violation. That means an additional forfeiture of $263.50, suspension of the driver's license for 60 days, or attend an alcohol awareness class. She's going to have to do probably both, the AODA assessment and OWI assessment follow through with Aurora, as well as the one with Mr. Hatch. And if she does not complete them, her license will be suspended. So that's what it is for the underage drinking first offense. All right. Is that all about the agreement, Mr. Fisher?
Yes, Your Honor.
Victims' rights are in compliance. Mr. Schmidt, the basis?
That's accurate. It does also involve a stipulation to the restitution. Maybe Mr. Fisher said that and I just didn't hear
Yes, to
it.
the $22,602.
Yes.
Okay,
So
minus the 2,500.
I think it's 2,400 because the clerks take like the surcharge off. So it's a little bit less than that, but roughly.
Okay,
So yes, the goal of this is to incentivize Ms. Taylor getting, dealing with the AODA issue. Jailing people not dealing with that doesn't make any sense. She actually completed that a long time ago. I believe Ms. Anderson indicated she completed IDIP back in May. The court recalls we've been going back and forth seeing if we could get insurance to pay the loss to the victim instead. That didn't work out, so she's been saving up money to pay what she can here. Obviously, it'll take a person of her age some time to pay back that amount of money. I think the amount she's saved up is already extremely large for someone at her stage in life with how this case has gone. So I think that's sufficient for the court to move forward. We couldn't just do IDIP because I thought the probation was necessary, as Mr. Fisher said, for collection, but also given the physical description of how she was drinking and driving, I think it is necessary to help supervise the alcohol there. And I think everyone would benefit from that as well. And the stipulation to the large restitution is pretty significant. This could have become some sort of knockdown, drag down fight about what was the nexus of the cause of that injury? What's the actual injury to the victim, with doctors and medical experts, and she's forgoing that and choosing to accept this here.
all right. But from hearing the victim's statement, it leads me to believe that there could be or may be a civil case.
There was a separate civil case, Your Honor. It's my understanding that that was handled by her insurance, as they were covering the civil side of things. The vehicle was insured. It's my understanding that civil matter has resolved.
More than just the auto? More than just that, because it sounds like he has future wages that he hasn't claimed. Or I just want to know what's going on. So is this full and final restitution?
That's my understanding, that this is the full and final amount the state's requesting for the criminal restitution.
Yes, the state, but I'm just trying to look at if you think that the civil matter's complete. Did it go through? I don't remember a civil case coming in front of me. Did one? Or was it just the insurance companies hashing things out?
I believe it may have just been the insurance companies hashing things out. I don't know for a fact, but I believe he did hire an attorney who may be in the courtroom. I'm not entirely certain if that's true or not, but I know he did hire a civil attorney who I had some communications with at the beginning of this case.
All right, and she's nodding her head. She is here. And so any civil liability cases, et cetera, that is fully resolved? Yes, fully resolved.
Yes, Your Honor, it has fully resolved.
And what is your name?
My name is Christina Kerr.
Can you spell your last name?
Yep, Kerr, state our number 1107432.
Thank you. And Christina, is it with a C or a K?
Christina.
Thank you for spelling that. All right, thank you. All right, so now I know where we are in the scheme of things and where we are in this matter. So formal motion to amend count 1 OWI second causing injury to a simple OWI second.
So made.
Granted on those reasons. Okay, do you have a plea questionnaire waiver of rights form?
Yes, may I approach?
You may. Thank you. All right, I have in front of me the plea questionnaire waiver of rights form. It appears that there are jury instructions attached to the document. Ms. Taylor, do you recognize the document?
Yes.
Did your attorney thoroughly go over this document with you?
Yes.
Did he essentially go over it word for word?
Yes.
And you understood everything contained on this document?
Yes.
However, if there was something you didn't understand, did you have him fully explain it until you did?
Yes.
And did you sign this document?
Yes.
It states that you're pleading guilty to an amended count 1 of an OWI second in 24 CF 247, and you are pleading guilty to 25 FO 248 underage drinking or possession age 17 to 20 first offense. Is that correct?
Yes.
You're 20 years old. You have 12 years of schooling. You can read, write, you understand the English language. And did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt to the OWI second and by clear and convincing and satisfactory evidence to the FO matter?
Yes.
And did he also go over with you the minimums as well as the maximum possible penalties you face?
Yes.
You are not receiving treatment for a mental illness or disorder, and you've not had any drugs, alcohol, or other medications in the last 24 hours, correct?
Correct.
Because you're charged with crimes, you are entitled to constitutional rights. Each of these rights is listed on the first page of the plea questionnaire. Did your attorney thoroughly go over that with you?
Yes.
Do you understand all of your rights?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that as it relates to the underage drinking ticket, that the state would have to prove that either you were drinking and you had alcohol or the possession of alcohol, you're between the ages of 17 and 20, and this would be your first offense. Do you understand what the state would have to prove?
Yes.
And again, do you understand that with that matter, there would be a forfeiture of $263.50, and the court will suspend your driver's license unless you attend the alcohol awareness class with restorative justice, which is separate and different from the one you did with the IDIP program, and you must do that within 60 days.
Yes.
Do you also understand that with regards to the OWI second, the state would have to prove on or around November 16th, 2024 in Burnett County, Wisconsin, having been a person who's had one or more convictions of an OWI, that you were operating a motor vehicle on a highway or roadway of this state and this county, and that you were operating it well under the influence beyond the state's legal limit. Do you understand what the state would have to prove?
Yes.
Do you understand that the maximum possible penalty could be, or it could be a minimum of 5 days of jail with a maximum of 6 months in jail, and that you could have fines not less than $300, but no more than $1,100. And that's simply the fines, no surcharges or anything else to that. The maximum possible penalty, plus due to the blood alcohol content here and the allegations that you would be also required to have the ignition interlock device for a period of 12 months. Do you understand that?
Yes.
And you would also have your driving privileges revoked for a period of 12 months. Do you understand that?
Yes.
Do you also understand that there is that agreement here where the court should follow the IDIP guidelines with the slight twist and turn due to the allegations and the facts of this case, and as it was stated on the record, but that I'm not bound to do that? Do you
Yes.
understand that? Do you understand that I could sentence you all the way up to the maximum possible penalty if I thought that was warranted? Do you understand that?
Yes.
Do you still wish to proceed and enter guilty pleas?
Yes.
Now, did you go over the criminal complaint with your attorney?
Yes.
And for the most part, as it relates to the facts alleged in that criminal complaint, are those facts accurate?
Yes.
Are you admitting here today that you in fact did operate a motor vehicle on a highway or a roadway of this county and this state while under the influence of an intoxicant?
Yes.
And this would be your second countable offense.
Yes.
Mr. Fisher, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor, and I did confirm that conviction remains unreversed and of record out of Washburn County for the
Thank you.
first offense.
Thank you. Are you pleading guilty to this offense because you are guilty?
Yes.
Has anyone made any threats or any promises to you for you to plead guilty today?
No.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
And you've discussed with him any facts that you know to exist?
Yes.
Are you satisfied with his services?
Yes.
Any questions for this court or for your attorney before I proceed?
When am I able to read my statement?
Very soon.
Okay.
Okay. And also, are you stipulating to the restitution in the total amount of $22,602?
Yes.
All right. Now, with regards to 24 CF 247, count 1, amended to OWI second without causing injury as a misdemeanor, how do you wish to plead?
Guilty.
As to 25 FO 248, underage drinking, first offense, how do you wish to plead?
Guilty.
Court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of the OWI second. I will also find you guilty of the underage drinking. The remaining counts and charges will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Sorry. As I said before, I think this is appropriate for the court to follow. Before today, Ms. Taylor had no prior convictions. Her underlying conviction was a Wisconsin OWI in Washburn County, which is non-criminal. So she's going away with this with the criminal conviction, a very large financial commitment towards the victim. I think that's substantial, even though the court's heard that that won't truly make the victim whole. He lost employment. That from the tenor of how he is speaking, I sense that he really enjoyed his employment, and that she's going to have to pay more money to be on the monitor, or if the court doesn't allow the monitor, for the jail sentence for that there. I think this is very significant. I think she's shown remorse and sincerity with agreeing to that very large financial burden for someone of her age with the criminal conviction and with prepaying that $2,500-ish before a court here today. And I'm sure it took her quite a while to save that up. The reason why we're not asking the court to do the IDIP guidelines, deviating a bit, doing that probation with it, doing the what would have been the IDIP sentence instead as conditional jail, is so that we still have the accountability there. That piece that's in the IDIP with that jailer monitor, it's still there. But this is a case with this fact pattern and this impact. It really merits the probation just to be really sure on this, just to make sure the community is really protected. And just to make sure Josie Taylor addresses the ODA issues, because we have that underage drinking ticket, that Washburn OWI was just in 23. We have this offense as well, and this offense also had that read-in of that paraphernalia. There are a number of things more science here.
Okay, Josie, excuse me. Argument,
Thank you, Your Honor. I would ask the court follow the joint recommendation here. And I've discussed, since I've been appointed to this case, which I understand it has been a long time, and I do apologize to the victim for the delay that has been caused by the misunderstanding with her insurance. Ms. Taylor has never intended to draw this case out because she was not accepting responsibility or did not think what she did was not just wrong, but I would agree with the victim that she is very lucky. Not only regardless of regardless of the resolution that the court decides is appropriate, she is lucky that the victim was not killed or injured further with gravely bodily injury, and frankly, I'm genuinely surprised based on my review of the discovery that Ms. Taylor walked away unscathed. It's honestly nothing short of a miracle to me. And I don't think Ms. Taylor will take that away. I think Ms. Taylor does take the seriousness of this away. And hopefully, while I don't want her to dwell on it by any means, I don't think that she will ever forget the impact that she caused to the victim here. And I would ask the court to follow the joint recommendation, given that if she doesn't make restitution payments or if she continues to not address her substance use concerns, the court can impose the penalties of up to 6 months imprisonment with the probation. I have explained to Ms. Taylor that if the court feels it appropriate, the court could continue to extend her probation. And additionally, considering the substantially large amount of restitution, which means that she could be on supervision for some time. And that jail time, while it could have been more substantial, I think for someone who has never served a sentence in jail, it is a substantial period, especially for someone her age. And I believe that the motivation not only to make the victim as whole as possible, understanding that nothing can ever fully really recuperate the harm that ever happened to him, but knowing that this is the closest thing that she can do in terms of also addressing her substance issues and making sure that she never puts anyone else at danger in the future and is not a danger on the road or in the community otherwise. And I would ask the court to follow the recommendation. I do believe she does want to make a statement today.
thank you. Ms. Taylor, I'm now going to ask you to provide your statement. If you read something, please read it slowly so that the court reporter can take it down. And I see that this has been emotional for you, and I'm not sure if the victim saw, but while you gave your impact statement, she was crying, and she's crying now. So I can see that this has impacted her. Not to say it hasn't extremely and devastatingly impacted the victim. So if you'd like to give your statement right now, you may.
Okay, can I start?
You may.
Okay. To the victim and the court. I want to start by saying how deeply sorry. How deeply sorry I am for my actions and for the pain I caused. I take full responsibility for what happened. There's no excuse for driving under the influence, and I regret it every day. Knowing that someone was hurt because of my choices is something I'll carry for the rest of my life. At that time, I was going through a really hard period emotionally, and I didn't know how to process what I was feeling.
Just take your time.
And instead of facing it in a healthy way, I turned to alcohol and substance to cope. I realize now that was wrong, not just for me, but for everyone around me who could have been affected by my decisions. Since then, I've worked hard to change my life. I completed all my assessments and programs, and I took them seriously. I've learned a lot about myself and about the impact of my actions. I got a job and I've earned a position managing the place where I work. That responsibility has shown me how much better life feels when I make the right choices and take accountability for them.
I'm sorry, I don't mean to interrupt, and I know that this is very emotional.
Yes.
But just slow down a little bit if you
Okay.
can, because since it is emotional and you are speaking a little fast, my court reporter really does need to take everything down.
Okay. I won't pretend that I've been perfect. I recently made another mistake by getting caught underage with alcohol and THC, and that was a hard wake-up call for me. But this time, instead of falling apart, I faced it. I owned up to it, and I'm using it as another lesson to stay focused on the person I'm trying to become. I'm truly sorry to the person I hurt. You didn't deserve what happened, and I wish I could take it back. All I can do now is keep bettering myself, stay sober, and live in a good way that honors the second chance I've been given. Thank you for listening to this and giving me the opportunity to take accountability and show that I am changing.
Thank you, Ms. Taylor. Ms. Taylor, you are very new to the criminal system, and I'm hoping that this is going to be it. All right. I hope you don't become more well-versed in the criminal court. And this was a doozy of a way to be brought into the criminal justice system. Even though an OWI first in Wisconsin is a forfeiture, it's a ticket, and you're underage, it still didn't have the same impact on you as this, because this is now a criminal conviction that caused injury to another. And we're not just talking physical, we're talking emotional, we're talking mental, we're talking financial. There are a whole lot of things associated with this crime and with the victim. And there's so much that we can't even understand because we are not going through it. He is and his family are. I'm glad to see the tears. I know they're real because it's very easy for me to judge and to tell when people are just crying to try and get the sympathy of the court. I can see that this truly has impacted you, and you say that it has impacted you and it will continue to impact you the rest of your life. Let that be. Let it continue to impact you, because you will think again when you're legally able to drink. You will think twice. You will think 3 times before you get behind that wheel. You could have not only injured somebody, injured yourself, you could have killed somebody. And to have that on your shoulders would be a whole lot worse. This is bad. That would be a whole lot worse. I have to look at the nature and the gravity of the offense. And again, this is very serious. It's an OWI second, and it did cause injury. It caused a lot of damage in all of the forms. I then have to turn and look at you. You are a young lady. You are 20 years old. You have barely even begun to live. Your brain has not even fully formed yet. This has not only impacted you in how you're thinking about your life and how you think about handling issues and problems in your life, which are good, but it has been a catalyst, I think, to have you work full time and to now work up and be a manager of your position. You are now in a responsible position, and you are a 20-year-old, and you can continue to better your life. Hopefully, you're going to look at taking additional education courses. Maybe you want a certificate, maybe you want a license, maybe you want a degree. Don't let this hold you down and define you. You can move beyond this, and hopefully in ways that can show the victim and the victim's family that you have learned and you are bettering the community and you are being somebody who can provide positive things to the community. I have to look at protecting the community, and here, this is a protecting the community, the public as a whole, because OWI cases are extremely serious, because anyone who gets behind the wheel while under the influence of any type of intoxicant is dangerous. The legislature tells us that, but we don't have to have them tell us that. We know that. I think the agreement is appropriate because it will place you on probation. You will have somebody watching over you. You will have the ability to engage in programs and services that can continue to help you. Because I don't think, even though the victim has been devastated, I don't think from hearing from his impact statement that he wishes ill will, that he just wishes negative things upon you. I think he truly wishes that you will do something positive with your life and you will not do this again. So with regards to count one, the court is going to order probation for the period of 1 year, 5 days of conditional jail. I'm doing an imposed and stayed sentence. I'm doing the max here because somebody could have died. So if you are revoked off of probation, 6 months of jail. All right. And even though the court will grant you the ability to have monitor for the 5 days, I'm not giving you necessarily the ability to do monitor if you're revoked. Because if you haven't learned your lesson and you're revoked off of probation, then there's the complete punishment factor of jail. $976 in the fines and fees plus the $10 blood draw fee. $22,602 in restitution. That's what you've already paid. 12 months ignition interlock device. There's a form that you can fill out at the clerk's office for half price. I'm sure you'll definitely qualify. 12 months of revocation of your driver's license. You may be able to get an occupational after a period of time. That's up to the Department of Transportation. With 25 FO 248, I'm ordering the $263.50. The AODA, the alcohol awareness class with restorative justice, that must be completed within 60 days. You contact Dave Hatch. If it is not, then your driver's license will be revoked for 60 days until that is completed. So it could go on and on and on, and that means no occupational driver's license. While on probation, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol, no place such as bars, taverns, liquor stores, casinos, or any establishment that has the primary purpose for the sale or the service of alcohol. I'm ordering a mental health evaluation and follow through. I do not know, and I'm not going to pry and to ask what issues you were going through at the time and what you were suffering from and why you reached to alcohol instead of a therapist. I'm not going to ask or inquire. And I'm seeing me even talking about this is impacting you right now. So a mental health evaluation and follow through, and that includes therapy and anything that is recommended, okay? Any program as instructed by your agent, all right? And I am going to order regular drug testing and or alcohol testing, if the agent believes that alcohol is being used, okay? You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. And so you're going to need to go to the jail's day reporting, provide your DNA. You have the ability to request it be expunged through a written letter to the Department of Justice, not to me, to the Department of Justice. I'm going to give you 45 days to report for your 5-day conditional jail. I am giving you the ability to be on our bracelet. That's 24/7 testing of alcohol, and it's GPS monitored. This is house arrest. The only places you may leave is to go to work and to go to any AA or therapy, all right? 25 hours of community service, and that must be completed within the first 4 months of probation. As long as it's with a nonprofit, it can be with the tribe, with the program with the tribe. It could be with a food share program. It could be with any type of, again, nonprofit. However, you must make sure that it is with a nonprofit or the tribe, and you cannot be paid or provided any type of gratuity. Okay? Restitution payments. You are currently employed and you work 40 hours. How
Yes.
much do you make an hour?
I make $8 an hour.
Oh, man, where do you work?
I'm a waitress.
You get tips?
Yes.
That's a lot of restitution to pay. And as Mr. Fisher did tell you, I will reiterate that if you don't pay off your restitution by the end of the year, I could extend you for an additional year, and I can do so again and again until it's paid, unless I see you are making a substantial, you're showing good faith in a substantial way towards paying off the restitution. At this time, I'm ordering $500 a month. If you can pay more, pay more. If you can't, then you can't pay more than 500 a month, then you can't, and then chances are likely that it's going to extend so the court can continue to monitor you. The Department of Corrections can continue to monitor you to make sure that restitution gets paid, because the number one thing with regards to justice is making the victim whole, or as whole as we possibly can. We cannot make him whole, but we can do what we can. And if you fail to make your monthly payments, because it is a condition of probation, you fail to do that, you could have sanctions such as jail time, which in that instance, I may not allow any types of monitor. It will be in jail. And you may have to start going to restitution court. Okay? If you fail to pay your fines and fees, not only will a civil judgment be entered against you, but the court will issue a warrant and you can sit an additional 6 months in jail. Probation will be collecting on your court costs and fees and restitution. Restitution is always paid first. I need to verify your address. Are you still on St. Croix Street?
Yes.
And telephone number ends in 4094.
Yes.
You are ordered to immediately report to probation after you provide your DNA to the jail, okay? Immediately go to probation to get this set up. And I'm not sure where you work, but it's at a restaurant. Probation can take a wage assignment, and perhaps you can just have the money paid for the restitution out of your paycheck. So talk to them about that. I don't believe the victim's requesting a no contact. Quite honestly, I don't even know where victim lives. All right. Have you, probably not, but I'm also gonna have you write an apology letter, and you're gonna do that through restorative justice. You're gonna do that, class 2, an apology letter to the victim. I know that you gave a statement here, it was very heartfelt, but I think it wouldn't hurt, and it would be a good exercise for you and for the victim. If the victim wants to read it, doesn't have to, but to do that class, okay? All right, and that has to be done within 60 days. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Fisher?
Your Honor, I would only ask if the place she waitresses at does serve alcohol. I would ask if she could be granted an exception except for employment purposes.
For this job, yes. For employment purposes, I'm not sure where she works, but for other jobs, it would have to be approved on an as-job basis.
Yes, Your Honor.
Okay. Nothing else?
Nothing else.
All right, then we are adjourned. Thank you.
Thank you.